does the path to this look like the standard and acceptable FBI DOJ process you're familiar with, or has it departed in ways that are improper or potentially unlawful?
I think that is absolutely the perfect way to start this analysis, because that's the thing that we know almost for sure, since we don't know everything about the government's case here. I think that the process is so important because you essentially have the president using the Department of Justice as a loaded gun that he can point at people. I think it's absolutely correct to relate it to the Eric Adams situation, to the Jimmy Kimmel situation, to using the levers of power in this unilateral fashion. Here, the things that are so unusual is you do not usually have a series of career people saying there is insufficient proof, and not only the career people saying that, but the Trump political appointee who was the sitting U.S. attorney agreeing with that. And what happens? This is somebody who is a Trump loyalist who is put there, who is removed. And because his view was that I'm not going to do something that he viewed as inconsistent with the facts and law. So you have career people and you have the Trump appointee saying no. You then have somebody who is on the case with no prosecutorial experience for essentially a New York minute, who obviously did not have the opportunity to review the facts, interview witnesses, hear from the defense, all of the normal things that you do as a prosecutor to assure the gravity of the situation before you bring a charge. And this just reads like I'm there to do one thing that the president directed in a tweet be done. Yeah. And obviously did not have the time to do that. And you have all sorts of signs, including an incredibly rare vote in the grand jury, where you're hearing that it's only 14 of the 23. They needed to get 12, so that just by the skin of their teeth were they able to get 14. And that bodes, just to be clear what that means to me, at trial, the government needs to prove their case unanimously. All 12 jurors have to agree to get a conviction. Here, they were only able to get 14 out of 23 on the very low standard of probable cause, which is a very low standard compared to proof beyond a reasonable doubt.
Let me join that point, because as you said, there's much we don't know. That's something we do know. And most Americans aren't sitting around memorizing the different vote standards in the criminal justice process. But to echo what you're saying, and I'll let you continue because I think it's so important as people make sense of it in this week we've had, the early standard is deliberately low. The government gets to move forward if they have some evidence. And they don't need, as you mentioned, a unanimous vote. So I would liken that to being tall enough to get on a ride at Disneyland. I don't know if everyone wants to spend their money at Disney right now or not. That's a personal decision, but that's like here. And then actually going to trial is like dunking in the NBA. You need to have evidence beyond a reasonable doubt where 12 people who come together as strangers all agree that with no other reasonable doubt or alternative reasonable explanation on the evidence and facts, this individual, whoever it may be, got up that day, went to Congress, and planned to lie and obstruct a proceeding. So again, picking up where you were, Andrew, with that mismatch alone, what does that mean about the strength of this case and how this same topic has already been investigated in the Trump first term by the internal DOJ watchdog and a special prosecutor, Durham, who looked at a lot of these related issues, and prior was not found to be a case?
Yeah, so, I mean, just to sort of, be a dog with a bone, the difference is that for the trial jury, it has to be unanimous, not 12 out of 23. It has to be all of the jurors. And it's not probable cause, it's proof beyond a reasonable doubt. And here's the problem. In the many, many investigations that were done of this and around this area, Dan Richman is on record saying that James Comey never told him to speak to the media. So if James Comey's going to say, I didn't do it, and the only other person who's part of that conversation said he didn't do it, you really have to wonder, where is the proof? And it starts looking like there's a reason that the career prosecutors and the former head of the Eastern District of Virginia were saying that you should not bring this case, because who are they going to rely on?
Well, and exactly, they may not want to fall flat on their face. That some people may give up their oath or do things they had previously found to be wrong for Donald Trump. Others think even if they do that, if the case were to blow up and fail, then they'd be sitting there with a worse problem personally in the
your own appointed U.S. attorney to put in, essentially a henchman to do this in one day, with no additional investigation, no individual review that we know of, and then the case is brought. I mean, it really is the stuff of autocratic regimes that we're seeing happen and unfold right before our eyes.